This video provides some additional information about the material that's in Module 2 of the course. The subject of torts is a subject that most people haven't thought about much, if they thought about it at all, but most court cases that are not criminal in nature are about torts. Torts are private wrongs. They are acts that are committed by private people or organizations that cause damage or injuries to other private people or organizations. If one person commits an act that causes damage or injury to another person, the person suffering the injury or damage can be entitled to recover damages, usually in the form of money, from the person who committed the act that caused the injury or damage. The two broad categories of torts, intentional torts and unintentional torts. The intention that is involved in these actions is the intention to do the act that caused the injury or damage, not necessarily the intention to cause the injury or damage. That's what determines whether a tort is intentional or unintentional. That is, the question is not so much whether the person doing an act intended to cause injury or damage to another person, but whether they intended to do the act. Intentional torts can also be crimes in some cases. For example, assault, which is causing someone to be in fear of being hit, and battery, which is actually hitting someone, can be both crimes and torts. If something's a crime, it's addressed in a criminal proceeding and can result in the person committing the crime being imprisoned or paying a fine or both. If something is a tort, it's handled in a civil proceeding, and the person committing the tort can be ordered to pay the person who was injured by the tort a sum of money. In addition to assault and battery, other examples of intentional torts are trespass, which means going on the land owned by someone else without their permission, defamation, which is saying or writing something about someone that's not true, and intentionally causing emotional damage to someone. Trespass, an intentional tort, can also be a crime, but defamation and intentional causing emotional damage to someone are not normally crimes. The other category of torts, unintentional torts, is usually called negligence, and it occurs when someone breaches a duty that they have, usually when someone acts unreasonably, and damages or injury results to someone else. There are four elements of a negligence case. The defendant, that is the person who did the wrongful act, must have owed a duty to the plaintiff, that's the person who was injured by the act. The defendant must have breached that duty that was owed to the plaintiff. The plaintiff must have suffered an injury or some damage. And the breach of duty by the defendant must have been the actual and the proximate cause of the injury or damage. Duties can arise from several sources. They can arise from laws. For instance, if the law says I'm required to stop at a stop sign and I don't, then I've violated the law and I have violated my duty that was created by that law. A duty can also arise out of a relationship. For instance, if I'm a surgeon and I operate on someone and make a mistake and cause an injury to that person, I've violated my duty as a doctor, which can be the unintentional tort of negligence. Duties can also arise out of specific situations. Everyone has a duty to act reasonably in every situation that they face. If I'm cutting down a tree, for instance, that's on the borderline between my property and your property, and it's close to your house, and I miscalculate where the tree is going to fall and it falls on your house, I've been negligent and I've damaged your house because I have not acted reasonably in that situation, and I've breached a duty that I owe to you to act reasonably. The second element of negligence is the breach of duty, and that's usually pretty clear. It means somebody hasn't acted in the way they were supposed to act. Third element of negligence is injury to the plaintiff, and that's also usually pretty clear. The fourth element of negligence is causation, that the breach of duty that caused the injury must have been the actual cause of the injury and the proximate cause of the injury. Actual cause is typically determined by applying what's called the but-for test. But for my wrongful act of cutting down the tree negligently, there wouldn't have been an injury to you. The tree wouldn't have fallen on your house. The other piece of causation, which is proximate cause, is about foreseeability. The damage that results from the breach of duty has to have been foreseeable when the act was done. If I do something that results in an injury to you, but it was not reasonable for me to expect that injury to occur, then my act might have been the actual cause of your injury, but is not the proximate cause of your injury, because I couldn't reasonably foresee that the injury to you would occur. If there's any questions about any of this information or other material in this module, please let me know and I'll do my best to provide more information.